Good morning to all of you. Dale Gallipo on behalf of the appellee. So I think the first important point is that in order to look at whether there was a constitutional violation or whether the law was clearly established, we have to, for today's purposes, assume all the plaintiff's facts.
Well, let me ask you, your colleague raised Scott, and I have a question about that. So the district judge said, after reviewing second by second that body cam footage which we've been talking about, he says, Lopez's hands were clearly empty at all times, and the tape blatantly, to use Scott's language, blatantly contradicts that. He had at one point a black object. It's in the district judge's own recounting of the video. So I just don't see how he got to the punchline empty at all times after literally saying just a couple lines ahead he had a black object in his hands at one point. And isn't that enough under Scott for us to take a more liberal review of the record?
Yes and no. First, I think it's a good point, and I noticed that as well. But the issue doesn't end there, because what's very important in a long line of cases that this court has had that are published opinions, a gun in someone's hand alone does not justify shooting someone.
No, but let's just go back. This is the Scott point, which is,
Okay.
Are we bound strictly taking all inferences, or does Scott give us more leeway because the video, in fact, blatantly contradicted what the district court concluded?
I think it does give you some leeway, Your Honor. But I think the real important point in this case, the most important point from the plaintiff's perspective, is that Mr. Lopez was complying with the officer's commands.
By pulling a black object out of his coat when the officer knew he was armed? How is that compliance?
When the officer told him to put his hands up, that's what he did.
At the end of this interaction?
If counsel wants to talk about perception reaction time, it works both ways.
But to Judge Donato's point, even the district court judge found that in the first 4 seconds in which that, it was, Xavier, get your hands up, and out of your pockets. There's a 4-second span in the video in which his hands are down here, and at one point he's reaching into his coat pocket and appears to be pulling something out, and we later find out that there's a loaded handgun in that pocket. And then it's at the end that his hands are raised and clear, right? Nothing in there.
Correct.
So I guess my point is, if we're looking at this from the standpoint of what Scott permits, he wasn't in compliance with officer commands for several seconds until the end. And my quandary with all this is, what's the clearly established law in that circumstance that would say that Officer Wright cannot use lethal force?
The clearly established law, first, we all know to use deadly force, there has to be an immediate threat of death or serious bodily injury.
Right.
Okay? So if we have a whole string of cases that we cited, Colonel George V. Morris, Estate of Lopez, and on down the line, when a gun in someone's hand is not enough. Certainly 2 hands visibly empty, up for 2 seconds, after you're told by a police officer to put your hands up, I mean, quite frankly, that falls within the obvious, because that's what we want people to do. Now, whether there was a 2 or 3 second delay, Your Honor, the bottom line is, where were his hands at the time of the shots? And he was complying. All these other cases that are cited, the people are not complying at all. In fact, at the time of the shooting, they either are pointing a gun, raising a gun, or reaching for the gun at the time of the shooting. So all of the cases that we cited that affirmed denial of qualified immunity, that held there was a constitutional violation, even the one case in 2017 where they said it was a constitutional violation, but the law wasn't clearly established at that time. It was clearly established before this incident, which happened in 2021.
Mr. Gallipo, what about Cervantes, where our court said just explicitly, if someone is reaching for a weapon, well, let me find out what exactly it says, but you're familiar with that case with Cervantes. if you're reaching for a weapon that clearly permits the officer to use some type of lethal force, why does that circumstance not apply here?
I think it's a great point, but let's talk about the main case the defense is relying on.
Oh, sorry, Cruz.
Cruz.
I'm getting
That's
confused.
okay.
It was Cruz.
Cruz v. City of Anaheim.
Right.
Now, here's what's important about that case.
I think the language is, it's unquestionably reasonable
Yes,
for an
and-
officer to fire in that context.
So two things are really important about that case, Judge Donato and Judge Sanchez. Number one, it's factually distinguishable because they had information that he was not going to go back to prison. He was non-compliant. They told him to get on the ground, and then he reached for his waistband. But in that case, the court also said it's a disputed issue of fact as to whether he was reaching for his waistband at the time of the shots. Therefore, we're denying qualified immunity. A jury has to decide that.
Yeah, but that's no longer the law. I mean, you can have a dispute of fact and still get qualified immunity, right?
Well, not if it's a material fact, Your Honor. You have to assume the plaintiff's facts, because if you're deciding if the law is clearly established or not, the question is based on what facts? If you take the plaintiff's facts,
Well, if I may, I think the requirement is for you to identify what's a, quote, squarely governing case that fits the facts here. And so what is that case? I think Judge
Okay.
Sanchez asked that. What is that case that makes it clearly a wrong thing, clearly a bar to qualified immunity here?
well, I would submit every case we cited where a person either had a gun in their hand but did not pose an immediate threat of death, or didn't have a gun in their hand. And the cases we cited were Colonel, George, Estate of Lopez, Villegas, Longoria, Landeros, and Hayes. Landeros, interestingly, Your Honor, which happened to be one of my cases, a person had a pocket in their hand, a hand in their pocket, and the officer suspected of gun, and they told him to take his hand out of his pocket. He took his hand out of his pocket. He shot within a second with a visibly empty hand. Here, from the plaintiff's perspective, this is a much stronger case, because having a gun on you is not enough. Even feeling threatened is not enough. There has to be an immediate threat of death. So can we really say, with someone's hands up and visible, after being told to put their hands up for 2 seconds, that we need a case specifically to say if someone is told to put their hands up and they do, and they're visibly empty, we need a case to say we can't shoot them?
Well, Casella says we do, and the problem is, it's what was happening in those preceding seconds when when he appears to be reaching for a loaded handgun in his pocket. Had he just immediately complied and raised his hands, I would be completely with you about this. But it's how can we divorce our analysis of this from what was proceeding just immediately before?
Well, it's important because it has to be at the time of the shooting. Let's take Cruz, for example. You brought that case up. Someone's reaching in their waistband. If that person was told stop reaching or put your hands up, and they put their hands up for 2 seconds, and then they shot him, I would be hard pressed for someone to say that's a constitutional shooting.
You do, you have to look at everything that's going on, and you know, you're an expert in the field. I know you know this. The qualified immunity is broad. It's intended to protect, as the Supreme Court has said, all but the most plainly incompetent and those bent on knowingly breaking the law. I don't see how any of this fits a situation where there's a known suspect who's armed with a semi-automatic weapon, who reaches in and out during his interaction with the police, and is at best partially compliant with an officer who has a weapon trained on him. How can you fault the officer in that context?
It's not a matter of faulting. It's a matter that it's...
Well, you are. You have to fault the officer to avoid qualified immunity.
Depending on how the jury finds the facts, I would fault any officer who gives a command to someone to put their hands up in a situation like this. The person puts their hands up. They're visibly empty for 2 seconds, and a highly trained officer shoots the person. Yes, I would fault that officer because I think it's clearly contrary to their training, to post standards, to any case. And You don't have to have a case exactly on all fours. And some cases fall within the obvious. But you could take any case where they shot a person for reaching and they stopped reaching. You're shooting a visibly unarmed person. What if hypothetically he had the gun, he took the gun out, and they said, drop it. And he dropped the gun. And they shot him after he dropped the gun. 2 seconds after he dropped the gun. Would we be saying, show me a case that says you can't shoot someone 2 seconds after they drop the gun? That's how absurd, in my opinion, with all due respect to your honors, because I have a lot of respect for all of you, I think qualified immunity is getting absurd. I really do. It's application to these cases expecting a published opinion, as if these police officers are home reading the Ninth Circuit opinions on the weekends. They're trained based on their policies and training that come from these cases. So when